Hey, good morning, LA aliens, Lalians, I guess. I've never known how to pronounce it.
Aliens.
Yeah, it's Thursday morning. We're back at Law and Legitimacy. It's that time of year. The Supreme Court's hopping, and we expect that today, the United States Supreme Court will release its blockbuster opinions in two cases pertaining to the use of racial classifications to allocate limited goods or scarce resources. In this case, the scarce resources being seats at Harvard and seats at the University of North Carolina. In two education-related cases, the court is being asked to consider whether equality before the law ever justifies treating some people as different than others on account of history, immutable characteristics, or whatever the variable. And it's expected that the court will conclude that affirmative action is unconstitutional as violating the Equal Protection Clause. We are likely to get a fractured set of opinions if there is a majority so holding. It won't be, 8-1, 7-2. It'll probably be 6-3. Ketanji Jackson is living up to the promise of as social justice in a dissent to a habeas corpus petition last week. She argued that there was something inequitable about application of the law in a situation where the law had changed and a person convicted under the law and found guilty is now regarded 20 years later as not guilty, given a change in law. Why can't he get a shot at justice? Strong intuitive appeal to that argument. There are strong institutional arguments about retroactivity and legal doctrine that suggests that's not the right outcome. The traditionalist won, she dissented. So, Ketanji Jackson, Sonia Sotomayor, they will certainly dissent, and there'll be strong and vigorous dissents. Let's see what happens. Lots going on legally in the world. Yesterday we talked about the Counterman versus Colorado decision and this emerging Supreme Court doctrine in the true threat case, and how that case represented a sort of, at least in my view, an unworkable standard going forward. And it led me to just have a lot of confidence in the world, though, that decision. Even though I disagreed with parts of it and disagreed with it strenuously, I was able to place my disagreement within the context of a rolling debate among scholars and professionals in the law. And the fact that that debate takes place is, in my view, a good and encouraging thing, because what it tells me is that we have institutions where we can still resolve our conflicts in a principled manner. We don't resort to force. We don't resort to intimidation to resolve our disputes. The courts are open to hear cases and controversies, and the universe is a blank slate. We talk a lot about lawyering here, and Mike and I have talked some, and even some on air, about potentially rolling out content for law students. And this would be the time of year to begin to think about it. And I'm reminded of, I tutored a young man through Duke. He did quite well. He was on the law review. He's on his way to a federal clerkship in the appellate court out west. And maybe he'll end up with a Supreme Court clerkship.
That's awesome, man.
And I remember before he began law school, I had him read John Locke's Second Treatise. And it wasn't that I wanted him to become a scholar of the 17th century, but I wanted him to understand, this notion that we are governed by consent. And I think I wanted to do more. And I didn't realize what I wanted to do until just the other day. So I'll share it with you. The key to practicing law is to understand the concept of a tabula rasa, a blank slate. And so whenever a legal problem presents itself to you, your first task is to identify the players. By analogy to game theory, what are these tokens, these lives on the board? What institutions do they have? What are their interests? Where do they want to go? So, for example, if you're on a monopoly board, you can only move in one direction unless you're sent certain steps back by a card or an instruction on the board. You don't get to decide, I'm going to go left when everybody else goes right. So you have people with you have tokens, you have destinations, you have people, you have interests, and then you have a broad set of rules that govern the sorts of cases and controversies, the sort of disputes these people will have, the obstacles that they will face in getting what they want. And so the goal of lawyering is ultimately, or the task of lawyering is, in my view, one of the most creative enterprises there is. And, with respect to Locke was an empiricist. He believed that we had a tabula rasa, that our minds were blank slates at birth. We didn't have innate ideas. You can disagree with that. There's a rolling philosophical debate about it. But his point was that what we learn from experience. And the law, as Oliver Wendell Holmes Jr. once said, isn't logic, but experience. It is the accreted, the acquired wisdom of generations, centuries, sometimes even millennia, of considered judgment about what to do when certain types of foreseeable disputes arise. How will we resolve them? And so we end up with legal doctrines, we end up with tests, we end up with institutions where people can go to advance their claims in the cases and controversies that the courts regard as justiciable, that is, as capable of being resolved. Nobody goes to court and says life is unfair, we're born to die. That's the poet's lament. It's not a litigation posture, even though it's true. So you go to court to work out a discrete case or controversy. And the thing that I love about June of every year is reading this, and especially as June progresses and as you get to the cusp of July, is you get to see the Supreme Court considering some of the most difficult and divisive issues in our society, and you get to see a learned response to them. And as you read, or as we read, and as we discussed yesterday in Counterman, there are a number of ways that these disputes can be resolved, and they always get worked out one way or another. And there are rarely unanimous decisions in the courts anymore these days. And that's because for most of these issues, there's more than one way to think about it. And so sometimes you simply have to identify the interests, the variables, and the rules, and you will be guided ultimately by a subjective sense of what the right outcome is. And that subjective sense will be informed by your own character, by your own philosophy, by your own position in the world, by your education, and by your background, which is why vetting of Supreme Court justices by the Senate is so important. I say this because I was talking to a friend of mine this morning. I know it's early, but I'm a talker, and we were on the phone. And I said, I sometimes think Sam Ervin did me a great disservice when he held the Senate Watergate committee hearings, and he'd reach into his jacket pocket and he'd pull out a Constitution and said, "My Constitution says," as though the Constitution read itself and interpreted itself to you. The fact of the matter is, as Theodore Roosevelt once said, life is strife, and we strive together and learn to live together and hope to live together under the rule of law. And the Supreme Court is where we work out these decisions and where we get authoritative decisions. What's all this? Why all this thumb suckery this morning? I used to write editorials for the Hartford Courant, the nation's oldest continuously published newspaper. They like to post, and we used to call certain pieces thumb suckers. When you didn't have anything else to say, suck your thumb and show people how it tastes. Well, I think there's more to it than that. I say this because when you read and when you hear discussions about the affirmative action decisions later in the day, try to imagine the passionately held position of somebody who disagrees with you and ask yourself why they're taking that position. Read the decisions, read the dissents, read the concurring opinions, and try to understand the values that the judges are bringing to their contemplation of the issue. Those values are a crystallization of pluralism, and our commitment to the rule of law isn't a commitment to always getting it right. Our commitment is to getting a rule that we can live with for the time being, with a commitment to revisit it if circumstances change. So I turn to the Harper v. Moore decision, which Mike and I were talking about briefly. We seem to be talking a lot about North Carolina these days. And it's not because Mike lives there.
No, it's because it's the center of the known universe. I've said this over and over and over again.
Well, it's the center of a universe that is knowable to some and who live there. For the rest of us, it's just sort of a minor league franchise where some of the issues that are likely to make it to the big leagues get tried out, and we get to see in real time.
And yet somehow we're among the Supreme Court cases and opinions that you can't wait to read. All of the issues that are dominating political discourse on the theme of legitimacy seem to find a battleground here. This is the center.
It does seem that way. It may be. So, we'll leave We'll leave North Carolina's claim to rival New England as a place where civilized people want to live to another day. But let's talk about more. In the Harper v. Moore case is notoriously difficult, and it has a very long procedural posture. But in the end, it comes down to this: in a society governed by written constitutions, who decides? Who has the right to decide whether a legislator's act is constitutional or not? Does the legislature have that right itself, or can the court, or does the court have that right? Does a court have that right? Now, understand the concept of judicial review is something that most of us take for granted. That is, that the court is the umpire and it gets to decide what the rules are in virtually every context. But that's a doctrine that had to be created and is unique in American law. At least that was a unique American tradition, which we've given to the rest of the world. It's not obvious that that it's right, meaning it's not obvious that that's necessarily what the framers intended. It's certainly not written into the Constitution explicitly. It took Justice Marshall to say that it's an implied power. It's explicitly the court's province to say what the law is and what the Constitution requires. So in Harper v. Moore, the legislature in North Carolina gerrymandered political districts, when congressional districts, when, for reasons that beggar the mind of all civilized men, North Carolina's population increased such that it was entitled to another congressional seat. Why people moved to North Carolina is an open question. It could be to enjoy Mike's beer, but we'll talk about that in a minute too. But so they had, so we've got a new congressional district. A given piece of geography we need to recalibrate the districts. And so the districts were recalibrated, but it wasn't a straight line process. We're going to draw a line from north to south and east to west and divide this state into X number of equal areas and whatnot. They were designed with a sensitivity to population density, but also with an eye toward political affiliation. And so we ended up with a system.
As is the nature of gerrymandering today.
Yeah. And so, it heavily favored the Republicans. Democrats challenged the methodology used by the legislature to create these districts. And the North Carolina Supreme Court spoke, and it made certain declarations about these being lawful or not. And so the question presented to the United States Supreme Court was, does a state Supreme Court, or candidly any Supreme Court or any court, have the right under the Elections Clause of the United States Constitution to interfere with a legislative decision?
Yep. And let me, if you will, allow me to just read what the Supreme. So anyone who's watching can go to supremecourt.gov, and these opinions are there for free to download. I know sometimes it's difficult to discern where to access these things, but they're all publicly available. And in particular, you can actually get the case history, procedural history, chronology of events, as well as a very short and plain statement of what question or questions are presented for the court to adjudicate. And in this case, Moore v. Harper, the question is as follows. It says, whether a state's judicial branch may nullify the regulations governing, quote, manner of holding elections for senators and representatives prescribed by the legislature thereof. And that's a reference to the Constitution, Article 1, Section 4, Clause 1. And replace them with regulations of the state's court's own devising based on vague state constitutional provisions purportedly vesting a state judiciary with power to prescribe whatever rules it deems appropriate to ensure a, quote, free or, quote, fair or free election.
And so the issue then becomes, if you are a person who feels aggrieved by the gerrymandering system. In other words, you're a Democrat, let's say, living in a Republican district, or you're a black person living in a district that's largely white, or vice versa. Can you bring an action? And the legislators' claim was that under federalism and under a strict construction of the Constitution, and only a state legislature and a state legislature alone had the right to declare districts. The Elections Clause vested that right in a state legislature, and it was an unreviewable right. No court could ever intervene. Certainly not the state court judiciary, and the reason for that is the supremacy clause of the United States Constitution.
Well, and is this what was regarded as the independent state legislature theory, the ISL theory? As you will see if you're reading articles about this stuff and you see references, that is exactly what Norm just described, is this position that was taken saying that state legislatures have essentially unreviewable rights to set the rules regarding elections, even in a federal context.
Well, and so you're like, how can that be? You're thinking, well, the Constitution says that they have this right. And so the independent legislature theory was when the federal Constitution allocates a power under the limited power, the enumerated power theories of the Constitution, it has acted. It has enumerated this power, and it has said that with respect to this act, the feds cannot intervene. It wasn't creation of a federal right. It was recognition of a state right in practice. And the claim was that no federal court could review this because Congress had allocated this power to the states. And you've heard us talk before about police powers. So the police powers over health, education, welfare, these always have been the province of the state in federal law. And thus, the great hue and cry over the Dobbs versus Women's Health Center case, repealing the federal right to abortion, merely returned a traditional source of regulation to the states and said, this is a state power. There is no federal right to do so. This independent state legislature theory isn't a police power, but what made this theory non-frivolous, in my view, was the fact that the Constitution used very strong words to give this to state legislators. Why I understand this decision and think the U.S. Supreme Court probably got it right is as follows. Even though a state legislature has the right to declare these districts, has the right to select the manner and means of how the votes shall be cast in their states. If a state were to say, well, no, people of color can't vote, or no, ugly Greek men can't vote, thus disqualifying me, we would have something to say about it because of cases like Baker versus Carr, which enshrines the principle of one person, one vote into our federal constitutional system. And so I think the claim is, I think the matter is correctly reviewable as a matter of federal law, because determining the scope of a constitutional power, where it begins and what it ends, is uniquely the function of the Supreme Court to determine. When the North Carolina, the more interesting and closer call, in my view at least, was North Carolina's claim that North Carolina's Supreme Court could not interfere in legislative judgments. And in that case, I think reasonable minds can disagree. I think that North Carolina, if this is a federal power given to the state legislator, then there's something called the abstention doctrine. And under the abstention doctrine, when federal law is declared and its goal is to occupy a certain field, to regulate in that field completely, the states can't interfere with that. They can't say, never mind, this is what the feds want to do, but we don't want to do it, because of the supremacy clause, the federal government being the supreme law of the land. So it seems to me that while the federal courts can review the decision of a state legislature to determine whether that state legislature honored the commitments of the federal Constitution, it's paradoxical for the U.S. Supreme Court to say, but that federal right, that federal power can be interfered with, or can be manipulated, or can be massaged by a state court applying its own laws. And so the decision makes me a little crazy, but you're saying, but wait, you were already such. Okay, it makes me a little crazier because now we have federalism, we have the supremacy clause, we have the Supreme Court saying, notwithstanding the fact that there is the elections clause vesting this power, this exclusive and independent power in state legislators to set the rules regarding federal elections, we're going to let state courts impose their judgments about what state legislators should do in exercising this federal power. Now, you're listening maybe, and maybe you stopped. Maybe you're thinking, this sounds like a bunch of gibberish and gobbledygook, and this is why I can't stand lawyers. That's an acceptable response. But you sacrifice a commitment to these deeper principles and relishing the paradoxes that the law presents. Because I think what drives the Moore v. Harper case, I keep referring to it as Harper v. Moore. I think what drives the case is again the value commitments of the various justices. And some people want to say, well, judges aren't supposed to make law; they're supposed to read it. That's just sort of a naive conception. When the Fourth Amendment says, hey, no unreasonable searches and seizures, we all know what that means, right? Because why? Because we know what's reasonable and what's not. Well, we don't. And there's a rolling consensus about that, which is why these issues become vastly socially significant and important decade by decade, and why the law evolves. With respect to Moore v. Harper, the independent state legislature theory, I don't know how I would have voted were I a justice. I think I would have been troubled by a federal court saying that state lawmakers can cabin in, can harness a power recognized by the federal government that belongs to the state. On the other hand, I'm not sure that I'd want to set the state or a state legislature free to do whatsoever it likes. What's at stake, I think, is a broader and more fundamental issue, and that is the comfort of people in their own home to set their own course. And so I guess if I had to decide this case, I probably would have decided in favor on these facts of an independent state legislature theory, because I think that one of the things that we did in the construction of our republic and in the embrace of the doctrine of federalism was to embrace sort of like the former House Speaker Tip O'Neill's line, all politics is local. That's what de Tocqueville said, when he toured the United States in the 1830s and wrote Democracy in America. He was overwhelmed by our commitment to local civic associations and our commitment to self-governance. And so I think that Moore v. Harper chips away at that. The response, of course, will be, well, no, it does no such thing. It gives the state courts the right, and these are close to the people in their states, to review a legislative determination to determine whether fundamental values about equality and one person, one vote are enforced. And right. Then I'd say you have to parse it carefully. If it's a federal right, a state court can decide a federal issue. But I don't think North Carolina's constitution trumps federal law. And to the degree that Moore v. Harper pushes the law in that direction, it creates a huge, as a certain president once said, tension and friction point in the law that will have untold consequences in years to come.
It's interesting that you make a reference to one President Donald Trump. But that's exactly where my mind goes on this issue. I think there's two questions here. One comes from Lawyer Will, and we'll get to him in just a moment. But
hey, Lawyer Will, you're back.
Yeah, he's here. Everybody give Lawyer Will a quick nod. But my question, Norm, is whether this is good on the whole for the various states of the union, as it were, in that we just went through the most contested election in American history, bar none, right? And the transition of power, as you've said, went on as scheduled. The republic remains, however divided and polar it appears. We continue forward. My question, though, is that when there are states such as Arizona, there are issues in states like Pennsylvania that make legislative changes and then do not even that legislative election rules for federal elections. In whom is vested the I guess standing to sue when a state does not follow its own rules regarding those elections? And does this ruling have any unintended or intended consequence to those issues? So, for example, does this give one state the ability or standing to sue another state for not following its own rules as promulgated, or to sue them for passing law that is violative of federal standards on
So I don't,
issues of federal elections.
I don't think interstate suits are going to go anywhere. I mean, if Pennsylvania sues North Carolina and says, our votes were diminished because you didn't follow your own rules, I just don't. I think as a matter of standing, I don't think a court's going to say, nah, that's going very far. I think Donald Trump tried that with respect to Texas suing, I think, Pennsylvania. I don't recall, and I think
I still think it's a legitimate legal theory, though. So if you and I disagree on that, I'm okay with it.
I don't know about that. I don't know that I've ever actually given it a lot of thought. I just think for prudential reasons, and you see the courts refer to prudential reasons, for reasons of prudence, for reasons of how we manage our docket, for managing the expectations of people about what the courts can and can't do, permitting interstate litigation where a resident of a foreign state goes to another state and says, it hurt me that you didn't follow your own rules. That's opening the door awfully wide to a lot of litigation. So, for example, would a Pennsylvania resident be able to sue in West Virginia because maybe a tobacco manufacturer or producer didn't follow a health regulation, and the result was somebody in Pennsylvania got lung cancer from secondhand smoke? Or more directly, with respect to adherence to environmental regulations, would a state downstream from an air polluter be able to say that I'm going to sue you because you didn't follow your own state regulations? For prudential reasons, at some point you got to stop the litigation whirligig and merry-go-round and say you can't. So I don't know.
I probably see it a little in a more narrow capacity than what I think and so that's a legitimate criticism. What is the scope there, and is it too broad? Will there be unintended and frivolous litigation as a result of that? I'm thinking only in the election context. I want to get to Lawyer Will's question, and then we will quickly transition to something else. Lawyer Will asks, so basically, can the judiciary have oversight of a state legislature's decisions on elections?
What does that mean, a judiciary? The federal judiciary or the state's own judiciary?
In the North Carolina context, the state judiciary, the state Supreme Court, actually did exercise oversight. And just some more procedural backdrop subsequent to, so there was Harper 1 and Harper 2. The procedural history here is interesting enough for anybody listening that doesn't want to read the full opinion, just to go and read like the first page of SCOTUS's opinion on this. It'll kind of give you at least an idea of how complicated this was. But the Democrat majority on the state Supreme Court overruled the partisan gerrymandered districts as they were drawn by the state legislature. Subsequent to all of this, a Republican majority on the state Supreme Court then vacated the prior decision of that Democrat Supreme Court majority and has not reinstated the original maps, but at least vacated the decision to nullify by the state Supreme Court. And so now there is a Republican-held supermajority in North Carolina that will take up this issue later this year.
Yeah, and all that makes my head spin.
So what my point is that this decision doesn't really get at that issue. I think I shared with you, Norm, before we started the stream, that I'm not even sure that this decision has remedied or resolved the
No, I think that's right. For me, the right decision comes to the following: state Supreme Courts can't apply state rules to to review state legislative decisions, because this is a power that the Supreme Court has taken from state courts by reposing it constitutionally in state legislators. However, federal courts and state courts sitting in judgment over federal questions can consider whether these legislative decisions comport with the federal Constitution. To the degree that, given the posture of this case, there's no application of a state court rule yet to review, my prediction is there'll be a Harper 3 once the court acts. And because I think the issue is just fundamental. It's a puzzle. And, I don't think there's a deeper way to think about it than the way that we just laid it out. You've got a power reserved to the state explicitly by a state legislator, a state legislature reserved by the federal Constitution to that. And how do you square that reservation with a state court's ability to apply a state court rule once the Constitution has taken that piece of the board off the or that token off the board.
I agree. And that's why I think the headline on this article from the Carolina Journal is brilliant. NC politicos offer mixed reaction to Moore v. Harper. And it talks about how the Democrat leaders, Governor Cooper, Attorney General Josh Stein are, taking a victory lap on this case. But, even the petitioner here, who you see on the screen there is Speaker of the House, Tim Moore. His disposition is basically, I'm just glad it's over. We've got other business to attend to, and this doesn't even really strike at the heart of the issue. So
Maybe.
And I think that that's the correct position to take. I mean, obviously, he didn't win this case, but I'm not even sure what a win would have netted the state of North Carolina or anyone else in this context.
I'm not either. It wouldn't have surprised me to see the court say that this controversy was moot, but it didn't. So listen, Mike, we got to do a hard stop today. I've got a long drive ahead of me. I'm doing court at 10 o'clock, and it's an hour and 15 minutes on a good day. That's assuming I don't run into traffic, and so I got to roll.
Understood. Well, quickly, and you can drop off, Norm, if you want to.
Okay, I better. Take care, everyone. Be well.
See you tomorrow.
I hope so.
Everyone, thank you very much for joining us this morning. We did have two other pretty big stories we were going to get to, that of the NCAA on the NIL memo that they released, as well as discussing the position of State Attorney General Josh Stein in the lawsuit Planned Parenthood v. Stein, in which he was a named defendant. He is the top the top legal officer in the state of North Carolina. The issue is that he has stated that he was not going to defend certain parts of a duly enacted state law regarding abortion here in North Carolina. So we will get to that tomorrow. There was a temporary restraining order hearing yesterday, and the court intimated that it was not going to grant a temporary restraining order for Planned Parenthood in full. If at all, it would grant it in a more limited capacity, but the preliminary injunction motion remains. So Norm and I were going to talk about the conflicting issues regarding Attorney General Josh Stein, simply because he's also running for governor of North Carolina in the 2024 election. So I think that that's something that, from a perspective of legitimacy, tracking that motif through our daily streams. And then on the NCAA NIL memo, just to prime everybody for that, the memo that the NCAA released was intended to be sort of a clarification on what the rules regarding NIL disbursements could be, how member institutions were supposed to govern payments to certain athletes, if at all, and who could participate, et cetera. But the key and fundamental issue that was revealed by the language of that memo is that the NCAA views itself and its policies as superior to those of state law. And recall that the NIL issue is one that is being taken up in state legislatures across the country. So we have a bit of a primacy issue with respect to whose rules matter most. So Norm and I will dive into that. It'll be fun. My position hasn't changed. I don't think that student athletes should be paid, but I'm fine with athletes being paid. So we'll see if that matters at all. To me, that is sort of an irrelevant issue, and the NIL issue in and of itself serves to highlight the illegitimate nature of the NCAA and how feckless its leadership has been over the past 20 plus years. So anyway, thank you all for being here. You know where to find us. We're on Rumble Video, YouTube Live, Twitter Live every morning, 8 a.m. Eastern, Monday through Friday. For those of you that cannot join us on the early mornings, if you have to jump in and jump out, these podcasts exist almost immediately after the streams are done on Apple Podcasts, Spotify, Google Play, Overcast, Audible, etc., wherever you find podcasts. And what we ask is that if you're here, leave us a thumbs up. Make sure you're subscribed, and if helpful, to enable notifications on that. If you're on Twitter, please follow Pattis Podcast and share this with at least one person. We're starting to notice some nice growth, and Norm and I, as he discussed earlier, are trying to design an additional offering that Law and Legitimacy can aspire to, especially in the way of legal education. So as we continue down that path, we really appreciate your support. We will, for lack of a better phrase, get our shit together and get a website stood up. We will collect your emails, and we will be able to sort of independently network with you and not be subject just to these platforms and the live stream feature. And we want that. I think that what I know of Norm and what the audience knows of Norm is that he has an enormous capacity and a prolific capacity for writing, and he has a very robust foundation in philosophy of law and the principles that govern our modern republic. And for that reason, it's one of my personal ambitions to reveal that to the world. I've been lucky enough to forge a relationship with him, and I think that it's easy enough for me to say this out of his presence because he's a very humble man. But we are lucky that he spends the time with us every morning that he does, and I feel humbled on my own to be able to bring some piece of what he has to offer to everyone here. So sincere appreciation and gratitude for all of you. Have a great rest of your day, and we'll see you back here tomorrow morning.